The deadliest contracts don't lie. They hide the truth in plain sight, and one clause on page 7 was about to destroy everything. The headquarters of Meridian Holdings occupied the 32nd floor of a glass tower that caught the light at certain hours and reflected nothing at all during others. It was the kind of building designed to project permanence, stability, control. The kind of place where decisions made in climate-controlled conference rooms could ripple outward and reshape entire industries. Daniel Carver had worked there for 11 years. He wasn't a CEO. He wasn't even a vice president. He was a senior contract analyst, a position most people outside the legal department couldn't define if asked. His business cards sat in a drawer, rarely distributed. His office was on the 28th floor, 4 floors below the executive suites, in a corridor where the carpet was slightly less plush, and the art on the walls came from corporate catalogs rather than galleries. But Daniel understood his role perfectly. He read the fine print, he catalogued clauses, he made sure every signature aligned with every term, every date with every obligation. He tracked amendment histories, cross-referenced annexes, and built spreadsheets that mapped the architecture of agreements most people signed without reading past the first page. He was good at his job because he believed in precision, not as a weapon, but as a form of respect. Words mattered, agreements mattered. When 2 parties shook hands and signed their names, that meant something. It meant you could be held to account. It meant your word had weight. Daniel had joined Meridian during a time when the company was smaller, still growing, still figuring out who it wanted to be. Back then, the founder, a man named Richard Holt, would walk the floors and speak to employees by name. He remembered birthdays. He asked about families. He'd built Meridian on the principle that a company should honor its commitments, not just to clients, but to the people who kept it running. Richard believed that business was fundamentally about relationships, that trust, once broken, was nearly impossible to rebuild, that the best contracts were the ones you never had to enforce because both parties wanted to uphold them. Then Richard retired. His farewell speech was brief and genuine. He thanked everyone, shook hands with the maintenance staff, and left on a Friday afternoon carrying a single cardboard box. The following Monday, his successor arrived. Victor Lang was everything Richard wasn't. Sharp-eyed, calculated, efficient. He wore suits that looked expensive even from a distance and spoke in the clipped language of someone who measured time in billable increments. Within his first month, he'd commissioned a consulting firm to audit every department. Within his first quarter, he'd restructured 3 divisions and eliminated redundancies, which was corporate language for letting people go. Within 2 years, Meridian had doubled in size. Within 5, it had absorbed 3 smaller firms and rebranded as a consulting powerhouse with offices in 8 cities and a client roster that read like a Fortune 500 index. Victor was brilliant. Everyone said so. He could see opportunities others missed, leverage assets others undervalued, and turn struggling acquisitions into profitable divisions within fiscal quarters that seemed impossibly short. Under his leadership, Meridian became untouchable. Competitors tried to poach talent and failed. Clients signed multi-year retainers without negotiating terms. The stock price climbed steadily, quarter after quarter, like a graph designed to illustrate exponential growth in a business school textbook. But somewhere in that transformation, something shifted. Daniel first noticed it in the language of the contracts. Clauses became tighter. Termination provisions became harsher. Grace periods disappeared. Penalty structures became more aggressive. The agreements still looked professional, immaculate even, but they felt different. Less like partnerships, more like traps. He mentioned it once to a colleague over coffee in the break room on the 28th floor. A woman named Sandra, who worked in compliance and kept a photo of her daughter's soccer team on her desk. She shrugged. "That's just how business works now," she said, stirring cream into her cup. "You protect yourself first. Everyone else is doing it." Daniel didn't argue. But he didn't agree either. He thought about Richard sometimes. Wondered if the old man ever drove past the building and looked up at the glass tower that bore his company's name. Wondered if he recognized what it had become. The trouble began with a company called Whitmore and Associates. Whitmore was a mid-sized consultancy that Meridian had acquired 4 years earlier. The deal had been celebrated internally as a strategic win. Whitmore brought expertise in regulatory compliance, a client base Meridian didn't have, and a team of seasoned professionals who fit seamlessly into the Meridian structure, or so it seemed. The acquisition had been announced at a company-wide meeting. Victor stood at the front of the auditorium and spoke about synergies, market positioning, and complementary strengths. The Whitmore partners sat in the front row, smiling politely, their futures secured by ink on paper. The acquisition agreement included a clause that guaranteed Whitmore's senior partners continued leadership roles within their division for a minimum of 5 years, provided they met certain performance benchmarks. Those benchmarks were clearly defined: annual revenue targets, client retention rates, project completion standards. Standard metrics, the kind of measurements that appeared in every acquisition agreement Daniel had ever reviewed. For the first 3 years, everything went smoothly. The Whitmore division thrived. They exceeded revenue targets in year 1, met them comfortably in year 2, came in just above projections in year 3. Their clients stayed, their projects delivered, their reputation within Meridian grew. Then, in the 4th year, Victor restructured the entire company. It happened over a single weekend. Employees arrived on Monday morning to find new organizational charts posted on the intranet. Divisions were merged, reporting lines were redrawn. Budget allocations shifted. Teams that had worked together for years suddenly reported to different executives in different buildings. The official memo used words like optimization and strategic realignment. It talked about eliminating silos and fostering cross-functional collaboration. It promised that the changes would position Meridian for the next decade of growth. What it didn't mention was that the Whitmore partners suddenly found themselves reporting to new executives who had different priorities. Executives who didn't understand regulatory compliance. Executives who viewed Whitmore's methodical, relationship-based approach as slow and old-fashioned. Projects were reassigned. Budgets were cut. Client relationships, carefully built over decades, were suddenly managed by people who didn't understand the nuances. Junior associates were pulled onto other teams without replacement. Software licenses were consolidated. Travel budgets were reduced. Performance metrics began to slip. At first, it was minor, a few percentage points below target in the first quarter, recoverable. The Whitmore partners worked longer hours. They took on additional projects themselves. They tried to compensate through personal effort for the resources that had been removed. But the structure itself had changed. Decisions that used to take days now took weeks. Budget requests that used to be approved with a signature now required 3 levels of authorization. Client issues that used to be resolved with a phone call now required formal proposals reviewed by committees. By the 3rd quarter, the Whitmore division was falling behind. Victor called a meeting with the Whitmore partners. It was held in a conference room on the 32nd floor. Floor-to-ceiling windows, a table made of some dark wood that had probably been harvested from a forest with a sustainability certificate, leather chairs that didn't make a sound when you shifted your weight. Victor was polite but firm. The benchmarks were contractual obligations, clear, measurable, non-negotiable. If they couldn't meet them, Meridian would have no choice but to reconsider their leadership positions. He understood that transitions were difficult, but the company had made significant investments in the restructuring. Everyone needed to adapt. One of the partners, a woman named Evelyn Marsh, asked a simple question: how can we meet targets when the resources to meet them have been removed? Victor smiled. Not unkindly, but not warmly either. I'm sure you'll find a way. You're experienced professionals. That's why we acquired your firm." The meeting lasted 12 minutes. 3 months later, the Whitmore division officially failed to meet its annual revenue target. The shortfall was 8%, not catastrophic, not unusual in a restructuring year, but contractually sufficient. Victor invoked the termination clause. The partners were offered severance packages and escorted out within a week. Security badges deactivated. Email accounts closed. Personal items boxed and delivered to their homes by courier. Most of them signed, took the money, moved on. Evelyn didn't. She hired a lawyer and filed a civil claim against Meridian Holdings for breach of contract and bad faith. She claimed that Meridian had systematically undermined the Whitmore division's ability to meet its contractual obligations while maintaining the appearance of compliance. That the restructuring had been designed, intentionally or not, to create the conditions for termination. The case was assigned to a commercial court. A trial date was set. And that manila folder, the one sitting on the boardroom table, contained Meridian's defense strategy. Daniel wasn't supposed to be in that meeting. His role didn't typically extend to litigation strategy. That was the domain of the General Counsel's office and the outside law firms that Meridian retained for high-stakes disputes. But Victor's legal team needed someone who understood the original acquisition documents inside and out. Someone who could explain the technical details, the drafting history, the intent behind specific clauses. Daniel had been the one to review the Whitmore acquisition agreement 4 years ago. He'd built the compliance spreadsheet. He'd tracked the amendment history. He knew the document better than almost anyone, still at the company. So they brought him in. Victor sat at the head of the table, flanked by Meridian's general counsel, a thin man named Robert with wire-rimmed glasses, and 2 outside litigators from a firm whose name appeared on skyscrapers in 3 cities. The lead attorney, a man named Gregory Finn, had silver hair and the kind of presence that suggested he'd won more cases than he'd lost. Gregory opened the folder and spread several documents across the table. The acquisition agreement, the performance benchmarks, email correspondence, quarterly revenue reports. "The contract is airtight," Gregory said confidently. Performance benchmarks were clearly defined. Ms. Marsh and her partners failed to meet them. End of story. Victor nodded. "Exactly. This is a nuisance claim. She's upset, but the law's on our side." Gregory tapped one of the pages with a pen. "We'll present evidence that the benchmarks were reasonable, that the partners had adequate resources, and that their failure was due to poor management, not company interference. We'll show that other divisions navigated the restructuring successfully. We'll demonstrate that the Whitmore partners were given warnings, opportunities to correct course, and support." "Do we have documentation?" Robert asked. "Extensive," Gregory replied. "Email chains, meeting notes, performance reviews. It's all here." Victor leaned back in his chair. "How long until trial?" 6 weeks. "And your assessment?" "We'll win. Cleanly." Daniel said nothing. He was reading. Gregory continued, outlining witness lists, document timelines, and courtroom strategy. Everything was methodical, professional, convincing. He spoke about burdens of proof, evidentiary standards, and precedent cases. He explained how they would establish that Meridian had acted within its contractual rights, that business decisions, even difficult ones, were not breaches of good faith simply because they had consequences. But something bothered Daniel. He flipped back to the 2nd page of the acquisition agreement, then to the 5th, then to an amendment that had been signed 6 months after the original deal closed. A single page, standard formatting, nothing dramatic. He read it again, then again. Gregory noticed. "Something unclear, Daniel." Daniel looked up. "Just making sure I understand the timeline." "Good. We need you familiar with every detail. You'll likely be called as a witness. Just answer honestly. Explain what the benchmarks mean, how they're measured, why they're fair. Daniel nodded slowly. Understood. The meeting continued for another hour. By the end, everyone seemed confident. The law was clear, the facts were documented. Meridian would prevail. Daniel returned to his office with a copy of the file. He sat at his desk and stared at the amendment for a long time. Then he did something he rarely did. He took the file home. The trial began on a Tuesday morning in a courthouse that smelled faintly of old wood and floor polish. The building was older than Meridian's tower, built in an era when government structures were designed to convey dignity rather than efficiency. High ceilings, stone columns, wooden benches worn smooth by decades of anxious waiting. The courtroom was smaller than Daniel expected, more functional than cinematic. Rows of wooden benches for observers, a judge's bench elevated just enough to command attention without towering. Fluorescent lights that hummed quietly overhead, mixing with the natural light filtering through tall windows. Evelyn Marsh sat with her attorney at the plaintiff's table. She wore a navy suit and kept her hands folded in front of her. She looked tired but composed. Daniel recognized her from the acquisition ceremony 4 years earlier. She'd given a speech about partnership and mutual respect. Everyone had applauded. Across from her, Victor and Gregory sat with the calm confidence of people who had already won. Victor's expression was neutral, attentive but not concerned. Gregory had a leather portfolio open in front of him, pages flagged with multicolored tabs. The judge entered. Everyone stood. Her name was Claire Pemberton, late 50s, silver-streaked hair pulled back, reading glasses on a chain around her neck. She moved with the efficiency of someone who'd presided over hundreds of trials and had no patience for theatrics. She settled into her seat and reviewed the case file without expression. After a moment, she looked up. "Counsel, are both parties ready to proceed?" "Yes, Your Honor," both sides replied. "Then let's begin." Evelyn's attorney presented their case first. His name was Michael Brennan, younger than Gregory, less polished, but there was something careful in the way he moved, something deliberate in how he organized his documents. He was methodical. He walked the court through the acquisition agreement, the promises made, the benchmarks established, the initial success of the Whitmore division, then the restructuring, the changes in reporting structure, the budget cuts, the resource reallocation, the timeline of declining performance that coincided exactly with the timeline of organizational change. He called Evelyn to the stand. She spoke clearly, without bitterness. She described how the Whitmore division had been integrated into Meridian, how the early years had been successful, how they'd built relationships with clients and delivered projects on time and under budget, how the sudden restructuring had pulled away the tools they needed to succeed. "We weren't asking for special treatment," she said quietly. "We were asking for the conditions we were promised, the conditions that existed when we signed the agreement." Gregory cross-examined her carefully. He was respectful but relentless, focusing on the numbers. Revenue targets, client retention, project timelines. He presented emails showing that the partners had been warned about their declining performance months before termination. Emails offering support. Emails suggesting strategies. "Ms. Marsh," he said, "isn't it true that you were given multiple opportunities to correct course?" "We were given warnings," she replied, "but we weren't given solutions, or resources, or time." The contract doesn't require Meridian to provide solutions. It requires you to meet benchmarks. Benchmarks that were based on conditions that no longer existed. Gregory smiled faintly. The benchmarks themselves didn't change, just your ability to meet them. Evelyn said nothing. Over the next 2 days, both sides presented witnesses, financial records, internal memos. Former Whitmore employees testified about the challenges of the restructuring. Meridian executives testified about the business necessity of organizational change. Accountants presented spreadsheets. HR representatives presented personnel files. Meridian's case was strong. The benchmarks were clear. The failures were documented. The law seemed straightforward. Then, on the third day, Daniel was called to testify. He sat in the witness box and placed his hands flat on the wooden railing in front of him. The courtroom felt both smaller and larger than it had from the gallery. He could see individual faces now. Evelyn watching him, Victor watching him, the judge watching him. The bailiff swore him in. He confirmed his name, his position, his tenure at Meridian. Gregory approached with a warm, professional smile. Mr. Carver, you were involved in reviewing the acquisition agreement between Meridian and Whitmore, correct? Yes. And you're familiar with the performance benchmarks outlined in that agreement? I am. Can you explain to the court what those benchmarks were? Daniel explained. Annual revenue targets based on historical performance and projected growth. Client retention rates measuring the percentage of existing clients who renewed contracts. Project completion standards measuring on-time delivery and client satisfaction scores. All standard metrics, all clearly defined. In your professional opinion, were those benchmarks clearly defined? Daniel hesitated, just for a moment. Yes. Were they fair, based on industry standards? At the time they were written, yes. Gregory nodded, satisfied. Thank you. No further questions. Michael Brennan stood. He was younger than Gregory, less polished, but there was something careful in the way he moved. Mr. Carver, he said, you reviewed the original acquisition agreement. Did you also review any subsequent amendments? Daniel's pulse quickened. Yes. How many amendments were there? One. Can you describe that amendment? Daniel chose his words carefully. There was one amendment signed 6 months after the acquisition closed. It clarified certain administrative procedures. Administrative procedures, Michael repeated. Nothing about performance benchmarks? Not explicitly, but implicitly? Gregory stood. Objection. Calls for speculation. The judge looked at Michael. Rephrase. Michael nodded. Mr. Carver, did the amendment change any conditions under which the performance benchmarks would be measured? Daniel paused. The courtroom was silent. He could hear the ventilation system, someone shifting in the gallery, the scratch of the court reporter's fingers on keys. It changed the reporting structure, he said slowly. The Whitmore partners were originally required to report directly to the board. The amendment changed that. They would now report through the Executive Vice President of Operations. And who was the Executive Vice President of Operations? At the time, a man named Thomas Ridley. Who did Mr. Ridley report to? The CEO, Victor Lang. Michael let that sit for a moment. So the amendment removed the Whitmore partners' direct access to the board and routed all their requests through an intermediary who reported to Mr. Lang. Objection, Gregory said. Leading. Sustained. Michael rephrased. Did the amendment change who the Whitmore partners reported to? Yes. And did that change affect their autonomy? Objection, Gregory said. The witness can't speak to autonomy. Sustained, but the seed was planted. Michael continued. Mr. Carver, in your experience, does reporting structure affect a division's ability to allocate resources? Daniel met his eyes. Yes. Can you explain why? Because resources, budgets, personnel, equipment are controlled by different levels of management. If you report directly to the board, you have one set of gatekeepers. If you report through intermediaries, you have more. Each level adds time, complexity, and the potential for priorities to shift. Thank you. No further questions. That night, Daniel sat in his apartment with the acquisition agreement spread across his kitchen table. He'd brought a copy home, something he rarely did. But this case felt different. His apartment was small, One bedroom, a kitchen barely large enough for 2 people. But it had a window that faced east, and in the mornings the light came in at an angle that made everything feel warmer than it was. He made coffee. Then he read. The amendment again. Then again. It was subtle, almost invisible if you weren't looking for it. But it was there. The original agreement gave the Whitmore partners direct access to the board for budget approvals and strategic decisions. Section 12, subsection C. He remembered reviewing it. He remembered thinking it was generous, unusual even. Most acquisitions didn't grant that level of autonomy. The amendment routed those requests through an intermediary, a position that hadn't existed when the deal was signed. The language was brief, professional. It used words like streamlining and standardization. It said the change would improve efficiency and align Whitmore with Meridian's corporate governance structure. But what it actually did was place Victor between the Whitmore partners and every decision that mattered. That intermediary, Thomas Ridley, reported to Victor. Daniel leaned back in his chair and stared at the ceiling. The benchmarks weren't impossible, but the system had been quietly redesigned to make them harder to meet. Not illegal, not explicitly, but not fair either. He thought back to the day he'd first reviewed that amendment, 4 years ago. He'd been sitting in a different office then, smaller, with a window that looked out at the parking lot instead of the city. The amendment had arrived via email with a note from Victor's assistant. Minor administrative update. Please review and file. Daniel had read it. He'd noted the change in reporting structure, but at the time it had seemed reasonable. Streamlining, efficiency, the language Victor used for everything. Besides, the performance benchmarks themselves hadn't changed. The targets were still the same. The measurements were still the same. On paper, nothing substantial had shifted. He hadn't questioned it. Now, sitting in the quiet of his apartment with traffic sounds filtering up from the street below, Daniel understood what he'd missed. The amendment wasn't designed to clarify. It was designed to control, and he'd signed off on it. He picked up his phone, put it down, picked it up again. He thought about calling someone. Sandra from compliance, Robert from legal. But what would he say? That he'd had a realization 4 years too late? That he'd reviewed a document and missed its implications? He thought about Richard Holt, the old founder who believed contracts were about relationships, not leverage. He wondered what Richard would do. Then he realized he already knew. Daniel opened his laptop. He started writing, not a memo, not an email, just notes. A timeline, a sequence of events, the acquisition, the amendment, the restructuring, the termination. He mapped it all out, step by step, a decision by decision. By the time he finished, it was past midnight. He saved the document. Then he made a decision. The trial resumed the following week. The courtroom felt different now, more crowded. Word had spread that something unexpected was developing. A few journalists sat in the back row. A law professor from the university had brought 2 students. Gregory presented Meridian's closing arguments with confidence, summarizing the evidence, emphasizing the clarity of the contract, and reinforcing that business decisions, even difficult ones, were within the company's rights. He stood before the judge with his hands clasped in front of him, his voice calm and measured. Your Honor, the facts are straightforward. Meridian Holdings acquired Whitmore and Associates under an agreement that clearly defined performance expectations. Those expectations were not met. The plaintiff's claim relies on the assertion that Meridian somehow undermined the Whitmore division's ability to succeed. But the evidence shows otherwise. Other divisions navigated the same restructuring successfully. The Whitmore partners received warnings, support, and opportunities to correct course. They simply failed to adapt. He paused. Contract law exists to provide certainty, to allow parties to plan, to allocate risk, to hold each other accountable. If we allow disappointed parties to rewrite agreements after the fact, simply because they don't like the outcome, contracts become meaningless. The law must respect the words on the page, and the words on this page are clear. He sat down. Then Michael Brennan stood. He walked the judge through the timeline again. But this time, he focused on the amendment. He moved slowly, deliberately, building his argument piece by piece. Your Honor, Meridian's counsel is correct that contracts must be respected, but contracts exist within a framework of good faith, and good faith requires that parties honor not just the letter of their agreements, but the spirit. He pulled out a document. This is the original acquisition agreement. Section 12, subsection C. It states clearly that the Whitmore partners shall have direct and unimpeded access to the Board of Directors for all matters pertaining to budget allocation, strategic planning, and resource deployment. He placed another document beside it. This is the amendment, signed 6 months later. It removes that language and replaces it with a single line. All divisional requests shall follow standard corporate reporting procedures. He paused. Standard procedures that didn't exist when the original agreement was signed. Procedures created after the deal closed. Procedures that gave one person, the Executive Vice President of Operations, who reported directly to the CEO, complete discretion over whether the Whitmore division received the resources it needed to meet its contractual obligations. He presented internal emails, budget requests from the Whitmore division, requests for personnel, requests for software licenses, requests for client development funds, each one delayed, each one reduced, each one routed through multiple levels of approval that hadn't existed before the amendment. The timeline is revealing, Your Honor. The amendment was signed in month 6. The restructuring began in month 42, exactly 18 months before the performance benchmarks were evaluated. Exactly enough time for the effects of resource restriction to manifest in declining performance. He highlighted specific dates, specific decisions. The pattern was clear. This isn't a case about performance failure. It's a case about a company that made promises, then systematically removed the conditions necessary to fulfill those promises. They didn't just move the goalposts. They locked the field, removed the equipment, and then penalized the players for not scoring. Victor's expression didn't change, but Daniel, sitting in the gallery, saw his jaw tighten, saw his fingers tap once against the table. Michael continued. The covenant of good faith and fair dealing isn't just legal theory. It's a recognition that contracts exist between people, not just on paper. That when you make a promise, you have an obligation not to undermine that promise through actions that technically comply with the letter of the agreement, but violate its fundamental purpose. He placed one final document on the evidence table. This is an email from Mr. Lang to Mr. Ridley, dated 3 months after the amendment was signed. It discusses resource allocation strategies for acquired divisions. And it includes this line: we need to ensure that acquired entities integrate fully into Meridian's structure and culture. Autonomy creates inefficiency. The courtroom was silent. Autonomy creates inefficiency, Michael repeated. The very autonomy that the original agreement guaranteed. The very autonomy that the amendment quietly removed. He turned to face the judge directly. Meridian had the right to restructure. They had the right to change reporting lines. They had the right to allocate resources as they saw fit, but they didn't have the right to do all of that while holding the Whitmore partners to performance standards that assumed conditions which no longer existed. That's not contract enforcement. That's contract manipulation. He sat down. The judge removed her glasses and set them on the bench. She looked at both tables, then at the document spread before her. I'll take this under advisement, she said. Court is adjourned. The courtroom emptied slowly. Daniel remained seated. He watched Evelyn gather her papers, watched Victor leave through a side door, Gregory following. He thought about the amendment, about the email he'd read at home, about the decision he'd made in the middle of the night. He'd written to Michael Brennan, explained what he'd found, provided copies of documents he'd reviewed years ago. He hadn't testified about it. That would have required disclosure, preparation, legal maneuvering. But he'd given Michael the roadmap. He'd pointed him toward the truth. The ruling came 3 weeks later. Justice Pemberton found in favor of Evelyn Marsh and the Whitmore partners. Her written decision was careful, measured, and precise. 27 pages. Single-spaced. It walked through the facts, the law, the arguments from both sides. She acknowledged that the performance benchmarks were clearly defined. She acknowledged that Meridian had the right to restructure. She acknowledged that contracts must be enforced as written. But then she wrote this: "The covenant of good faith and fair dealing is not merely aspirational. It is a recognition that contracts exist within relationships, and relationships carry obligations beyond the explicit terms written on the page. When a party makes a promise, particularly a promise about conditions, resources, or operational structure, they undertake an implicit obligation not to undermine that promise through subsequent actions that, while technically permissible, fundamentally alter the context in which the promise was made." In this case, Meridian Holdings promised the Whitmore partners continued leadership and autonomy, subject to clearly defined performance metrics. 6 months later, Meridian altered the operational structure in ways that removed the autonomy upon which those metrics were predicated. 18 months before evaluation, Meridian restructured in ways that systematically restricted the resources necessary to meet those metrics. The court finds that while Meridian's individual decisions were within its rights, the cumulative effect of those decisions, particularly when viewed in light of the amendment that removed direct board access, constituted a material change to the conditions under which the performance obligations were intended to be measured. To hold otherwise would permit any acquiring company to make generous promises, wait for the signatures to dry, then systematically dismantle the conditions necessary to fulfill those promises while invoking the promises themselves as grounds for termination. That is not contract enforcement. That is contract evasion. The court finds that Meridian Holdings breached the implied covenant of good faith and fair dealing. The Whitmore partners are entitled to reinstatement with appropriate protections, compensatory damages for lost wages and reputational harm, and reasonable attorney's fees. Victor appealed. The appeal was denied. 6 months later, Daniel stood in the same boardroom where it had all begun. The city stretched below, the same as it always had. Morning light reflecting off glass towers. Traffic moving in patterns that looked random from above but followed invisible rules at street level. The room felt different now. Victor had resigned quietly. No scandal, no investigation, just a carefully worded press release about pursuing new opportunities and spending more time with family. He'd received a severance package that was generous by any standard and devastating by none. He'd left on a Thursday afternoon, walking out the same doors Richard Holt had walked through years earlier. The new CEO was a woman named Laura Hines. She'd been with the company for a decade, worked her way up through operations, and was known for asking hard questions. She'd been the one who, during a restructuring meeting years ago, had questioned whether Meridian was creating efficiency or simply cutting resources. Victor had thanked her for her input and proceeded with his plan anyway. Now she sat in Victor's old chair. She'd asked Daniel to join her for a meeting, 8 a.m., coffee already waiting when he arrived. She didn't waste time. "I've been reviewing our contract processes," she said, "not just the legal compliance, the intent behind them, the patterns." Daniel nodded. "That's important work. I've read the Pemberton decision, all 27 pages. It's illuminating." She pulled out a folder. Inside were contracts, acquisition agreements, amendment documents, performance provisions. "I want to make sure we're not just legally compliant. I want to make sure we're fair, that when we make promises, we keep them. That when we write agreements, we honor the spirit and not just the letter. Daniel looked at the documents. He recognized some of them. Deals he'd reviewed. Language he'd catalogued. "That's the right approach," he said. She smiled faintly. "I'm told you're very good at reading the fine print. That you understand not just what contracts say, but what they mean." "I try." "Good." She slid the folder across the table. "Because I'd like you to lead a comprehensive review of all our acquisition agreements, current and pending. I want to know if we're making promises we can't keep. If we're creating conditions that undermine the agreements we're signing. If there are amendments or provisions that look harmless but carry implications we haven't considered." Daniel opened the folder. Saw names he recognized. Divisions that had been acquired. Partners who had signed and stayed, or signed and left. "This will take time," he said. "I know. It might reveal things that are uncomfortable. I'm counting on it." Daniel looked at her. She met his gaze steadily. She meant it. "I'd be honored," he said. She extended her hand. He shook it. Her grip was firm. "One more thing," she said. "I'm creating a new position, Vice President of Contract Integrity. I'd like you to consider it." Daniel paused. That's a significant change." "It's a significant need. We've spent years building systems that protect the company. I want someone focused on making sure those systems are ethical, that they serve relationships, not just legal positions." "That's what Richard used to say." "I know. I learned it from him." Daniel looked out at the city. Somewhere out there, Evelyn Marsh was rebuilding her division, leading her team, working with clients who valued her expertise. Somewhere, a contract analyst at another company was reading a clause and deciding whether to speak up, whether to question the language everyone else had approved, whether to risk being uncomfortable in service of being right. He thought about the amendment he'd signed off on 4 years ago, about the email he'd sent to Michael Brennan in the middle of the night, about the choice he'd made to point toward the truth even when it implicated his own oversight. He thought about what that choice had cost and what it had meant. He turned back to Laura. "I accept." She smiled. "Good. Start Monday. Your new office is on 32. "The executive floor?" "If contract integrity isn't an executive priority, we're doing it wrong." They stood, shook hands again. Laura gathered her papers and left for another meeting. Daniel remained at the window, looking out at the city. Below, people were starting their days, making deals, signing contracts, building relationships on foundations of words and promises, and hope that those words would be honored. The glass tower reflected the morning light. For a moment, everything looked sharp and clear, like the world was drawn in lines that couldn't be crossed. But Daniel knew better now. He knew that the most important lines were the ones you couldn't see, the ones between what was written and what was meant, between technical compliance and actual fairness, between protecting yourself and honoring others. He picked up the folder and headed toward the elevator. His new office was waiting. And for the first time in a long time, Daniel felt like the words on the page and the truth in the room were finally aligned.